So we've got Tony Busby coming to be our kind of main speaker. Toro, who's associated in his office, is going to chat with us for a while too. Tony's running about 15 or 20 minutes late, so I thought while we're waiting for you to show up, I'll handle a few housekeeping. First of all, medically speaking, I'm totally fine. This is the top that I use. I do a little dance routine. And that's going to be after lunch. Around. What happens? It's really impressive, and I've been practicing routines like junior high talent show. So stick around for that. This is, I believe, our third or fourth installment of our Friday CLE. We're hoping to build that into the fall and keep on going. We've got ideas on topics you would like to hear about. You've got my email address. You probably got Erica's. Feel free to email us your ideas. We're thinking that we will probably, well, hopefully, we'll see how it works out. But we are aiming to have one or more of the lawyers who are trying the Alex Jones case in Austin. So I don't know. We'll see how that turns out. That's what we're hoping to have sometime maybe next month. But you'll all get RSVP or get invitations in your email or by text. And hopefully they can come by and share all of the crazy. I was actually there for 2 days this week to watch the trial. Yeah, I was there live. Last 2 days of that trial were crazy taco wrapped in the same burrito. Goofy sauce. I mean, just, you've never seen anything like it. And rare that you see something behave that way. Totally crazy. So today's topic is going to be sexual assault cases. I don't know how many of you guys have handled those. They're really pretty tricky. I've handled maybe 4 or 5 over the years. My biggest problem with those cases is recoverability, right? Usually sexual assault is a intentional tort, just like any assault. And it's really, it is narrow circumstances whereby the assaulter has any funds to pay off the judgment. And even more rare that you can tag an insurance company to be responsible for that. I've handled a handful of sexual assault cases that did involve commercial defendants. There's been some good developments in Texas law. There was a case a few years ago called Steak and Shake that clarified the issue of whether or not sexual assault in the workplace was covered as essentially a comp plan under the Texas Commission on Human Rights Act. Or if you could bring negligent hiring, negligent training, negligence, or respondeat superior case. And so that's been clarified in the last few years, but I have really only just dabbled in that topic. Crystal and Tony have done a bunch more of these kinds of cases. So with that, I was going to introduce Crystal, and maybe she can chat with us for just a few minutes before Tony gets here. But we're in a pretty small setting. We've got a bunch more people who are participating via Zoom, and they typically aren't able to ask questions. But if you guys have questions as we go, feel free to let us know. Also, I think everybody knows this, but when we're done in about 45 minutes or an hour, we've got a full lunch spread upstairs. It's got booze and a bunch of barbecue, and it's really a whole lot better than CLE itself. So come for the mad learning from Crystal, but stay for the cocktails and the barbecue. So Crystal is born and raised in Allen, Texas. She went to UH Law and graduated in 2014. She's been an associate at Busby Law Firm for I think all that time. Right. And she handled complex commercial litigation cases, personal injury matters, and recently has handled quite a few sexual assault cases. So I'm going to turn it over to Crystal, who's going to give us some basic stuff, and then Tony will hopefully be ready.
Well, he's having actually a hard time finding it. Can Peter call him and wrangle him?
Take me back.
Every time I try to get out, they bring me back in.
Peter, Tony was. So hopefully that's right. If worst case scenario, we'll throw some barbecue at me as you drive by. All right, I'm going to give the floor over to you, and I'm going to go see if I can help you.
So sexual assault litigation is a very passionate thing. I'm very passionate about. Pride and representing the they're really not easy cases. There are complex issues involved in terms of, victim shaming and overcoming those kinds of obstacles, especially where there is no evidence or eyewitness testimony. Those cases have proven to be a lot more challenging, and most recent cases on the headlines, for the last year and a half with the Sean Watson case. I mean, there was what helped us establish proof of, helped us meet our burden of proof, for that this guy was exchanging text messages and on Instagram, so it's all documented. And some of the things that also helped were the fact that he apologized to women doing that. Sorry, I made you feel uncomfortable. Sorry that I think you were. So that helped our case, but in many instances, we don't have that evidence available. That makes it a lot more challenging. But I think the obvious also when it comes to identifying, and I'll let Tony give his spiel because he's very good at kind of navigating through. There have been times where we've had cases that I'm like, this is a dog shit. There's no case. I don't get it. And he has found, he'll like look at things from a different perspective, and it really changes the trajectory of the litigation. Best example was this case. That case was not a case that anybody wanted to mess with, and nobody wanted to sue the beloved quarterback. They certainly weren't willing to stick their neck out on the line, facing that criticism. But we took a chance, and we thought his perspective was if he's done it once, he must have done it a time or two before. To be quite honest, when he circulated a drop of the petition initially, he circulated it to attorneys, and he asked for our opinion. We were of the opinion that he shouldn't file that lawsuit. And he said, watch and learn. And he took a big risk, and he filed that lawsuit, and it made national headlines within the next 24 hours. And all these women, he did it to me too. I had the same experience in all different parts of the country, not just in Texas. And so I don't think that he told his lawyers, what he was doing, because I think he was ill-advised and thought that, that was going to be a smart move. But since prior to that case, we've handled cases against Goodwill. There was a case we had where she was a 33-year-old woman at the time with the IQ of an 8-year-old child. She was working at Goodwill. It was her first job. And she went to her manager, and Goodwill's mission is to help people find employment who have barriers to employment, a language barrier, a criminal history, a physical disability, or otherwise. And so they group the most vulnerable members of society, like the mentally incapacitated, with predatory criminals with no safeguards between. And so our client told her supervisor one day, I forgot my lunch, I'm really hungry. Her name is Gloria, sweet Gloria. And she, the supervisor said, I'm sorry, I can't do anything. Try not to forget your lunch. So ex-convict coworker overhears the conversation and said, well, I can take her to lunch in my van, literally. And the supervisor lets this woman go to get lunch at McDonald's, and he proceeds to rape her in the van. 5 months go by, and he said, better not say anything to anybody because you lose your job. And Gloria left her job, it's her first job. 5 months go by, and she complained. Oh, and apparently she had a little crush on this guy, which doesn't make it any better because she mentally could not. She's like a child. We should have given the management more notice to keep her away from him, but on the contrary. So 5 months go by, and she's complaining of excruciating back pain to her mother. And they rushed her to the emergency room, and she gave birth in the parking lot in March. It's very cold in Amarillo in March. Gave birth to a 2-pound premature baby in the car. They didn't even make it inside. And that's when we figured out, Gloria, what happened? How are you pregnant? And that's when the story became known. That case against Goodwill was one of the first sexual assault cases I've handled at the firm, but by far the most memorable because just of the dynamics and just how badly they screwed it up. And so obviously Goodwill is a charitable organization. There was half on that in the years ago. But that was an interesting case, and we've handled many others like that. I really like them. I think those cases are fun. I think they're interesting. I think you're helping people when you represent them. Hi, Tony. Well, I'm going to give a quick introduction to Tony. I'm going to read his bio to y'all, and I'll let him get started. I'll have a few questions.
Oh.
And then we'll take.
How are you?
The New York Times described Tony Busby as one of the most successful lawyers in the country. Tony Busby graduated from Texas A&M University with a Bachelor of Science degree in psychology.
Skip over that first part.
After leaving the Marine Corps, Busby entered law school at the University of Houston Law Center. While there, Busby was the managing editor of the Houston Law Review and was elected class captain. Busby was also state and regional mock trial champion. Busby ultimately graduated summa cum laude, second in his class. Mr. Busby has tried multiple cases to verdict, obtaining more than 10 billion in verdicts and settlements over the course of his career. He's the subject of the book Defining Moments and has appeared on the cover of New York Times Magazine. In 2015, Mr. Busby was named Attorney of the Year by Texas Lawyer due to winning 8 cases in a single year, including verdicts of $159 million, $41 million, $35 million, $39 million, $30 million, and $12 million, all while also representing Governor Rick Perry in his criminal case that Busby was ultimately able to get dismissed. Busby has the highest verdicts award in multiple courts across Texas. Texas Monthly said of Busby, Busby has made his name going after corporations and usually wins big. The New York Times described Busby like this. Mr. Busby's a big, mean, ambitious, tenacious, fire-breathing attorney.
I was heavier then.
Texas crime, really big.
I lost a lot of weight then. They were really focused on my size.
So I want you to get up here and talk to us about it. No, we're just gonna do more interaction. But one of the questions that we have for you is how do you identify civil sexual assault cases? Because there's, many young lawyers are signing up cases sometimes that they're looking for, and, there's not a case. And so how do you identify what is a good potential civil sexual assault case?
First off, let's remember this. There's 460,000 sexual assaults in the country every year. 70% of those are not reported. 1% of those are actually prosecuted. So what does that tell us? That tells us that in our line of work, there's a lot of business to be had there. I can tell you that and I'm going to focus on women because typically the client that comes in the door is a woman. It takes a lot of courage for a woman to step forward and say, I've been wrong. Lots of research has been done on this. If this is a line of work that you're interested in, you really, really should do the research. You really should understand what you're dealing with before you attempt to represent somebody who's been through something like this. Because most of the people that we get calls from, they've been wronged in all kinds of ways. And the last thing you want to do is wrong them yourself by being a man, as an example. Just the way that we are.
It's part of our genetic makeup. I don't know what it is, but it's, I've been blessed that I have people like Crystal and others at our law firm who probably are better at understanding and empathizing with people. They're not looking for sympathy. They're looking for empathy. Big difference. So first off, I want you to understand the breadth of the problem. It's shameful. As an example, I'm just going to do this latest case with Deshaun Watson. This young woman had went to, she'd been abused and criticized because she went to several lawyers because the lawyers didn't know if they could help her or how they could. When she came to our firm, when the case was presented to me, and we probably get, 50 to 100 cases a week that I have to review. I started Sussman Godfrey. One of the things I learned there was every lawyer in the firm screened every case, and everybody had a vote about what cases we work on. He's our friend, Steve Sussman. God bless him. Dan, as you probably know, was a great mentor to me, and I learned a lot from him. And so every case that comes into our firm, I screen the person, and I decide whether to take it. That takes up a lot of my time. But it also, obviously, is our brain. This particular young woman some of the lawyers in the firm really thought we could help her, really wanted to represent her. I, being the idiot that I am, turned her away. I didn't want to fool with it. You know, I'm thinking about time, the time value, the value of my time. And I was thinking, well, I'm not sure how much the cases were. I'm thinking about my other docket obligations, et cetera. And I really feel a little bit, we talked about this, a little ashamed that I turned her away twice. And then I remember I finally said, all right, well, I will meet with her at least. Remember, I'm the kind of person that I have lawyers that work in my firm that I've never met. Right? My thing is, after a year, if you're still here, then I'll invest some time into you. I know that sounds crass, but that's just how it is. If you have active practice, that's just how things are. So I met with her and I was compelled. I was persuaded. But even then, it was a situation where, okay, I'll send a letter for you. That was the best that I would commit to. And the truth is that Pete worked on this case too. I know Pete, the best mediator in town. I recommend him highly. Law school class. I sent a letter, and but for the fact that I dealt with a lawyer, I can't mention his name, and I can't criticize him. It's called a non-disparagement. But in any event, our interaction was not a positive. Can I say that? Is that okay? I think I'm saying that. Yeah, that's good. But it pissed me the hell off, to be honest. But for that interaction, I probably still wouldn't have taken it. And had I not taken her case, we wouldn't have had 30 cases. And we're evaluating maybe 100 right now. Very similar. So I guess the first thing I could tell you is try to educate yourself, because I've now educated myself. I was probably not very receptive and very empathetic as I should have been. So that's the best advice I can give you. Obviously, the problem is huge in the United States. There's a situation where somebody is powerful, somebody's not powerful. It's typically sexual assault is typically not, has nothing to do with sex. It has everything to do with power. See somebody nod your head, you understand that. Others are like, oh, really? Okay. That's why I'm saying educate yourselves. But beyond that, I would tell you that, I still, there's a woman, a lawyer in Dallas who I think is just, I've never met this woman, but I think she's fabulous, who does a lot of these cases and gets great verdicts.
Tito?
Yeah, I've never met her. I'm giving her a plug, I think she does great work. I think she's got it figured out. I think we've got it figured out here in Houston. But what I would suggest you do when you're taking these cases, when you're screening these cases, is give them the benefit of the doubt. Because I think most people who live in the real world understand that it's more than emotions, it's more than filing cases. There's a human element here that's incredibly important, and I have found that our juries understand and care about that.
So to ask a specific question,
Yes.
I've seen a fair amount of sexual assault cases, and a lot of them, I just can't find a viable defendant that have any chance. Most sexual assault are not by NFL football. They're not, a lot of them aren't in the workplace. What do you look for on the issue of recoverability?
Joe Jamel used to say this. Joe Jamel, who purposely mispronounced my name multiple times until I told him one time I'm gonna piss on the grave. God bless him. Called me Mr. Bugsby all the time on purpose. Very smart. He knew exactly how to get under my skin. He used to say that a personal injury case, to your point, is a stool with 3 legs. Right? One leg is liability. You have to have the second leg is damages, and the third leg is recoverability. That is somebody pay. What he would always say is that I can sit on a stool with 2 legs, as long as one of those legs is somebody can pay. I can work on damages. I can work on liability. I can't make somebody who can't pay. Right? I take a different view with these kind of cases. Sometimes there's something to be said, and maybe I'm, on my lofty perch here that I don't really do this for money. Maybe I have that luxury that I think there's something to be said for going and getting the verdict to get somebody who cannot pay because of their conduct. So I'm not sure that answers your question, but for me, I will take a case, even when I know that there's no recovery. Obviously, the last case, which I can't talk too much about, was different. But as right now, I'm looking at cases against DPA, jail. There's a lot of those there. There's also just a case of husband and wife, with a husband, it's just a creep. And I take those cases just because it's a statement to be made. Another example is if you think about there's a case in Corpus right now against a guy that was sexually assaulted and shot a woman in the back of the head who's doing life in prison. We didn't have a pot to listen or we could throw it out. It needs to be done. So I'm not sure that answers the question. I think your point is well taken, that a lot of times there's nobody that can pay. But from my point of view, I don't care. What else?
Okay, let's talk about, now that we've talked about that, sending demand letters, you think that's a good strategy?
Yeah, I think so. You guys remember Cadillac Ranch? You don't know Cadillac Ranch? If you've driven Route 66, Cadillac Ranch, it's part of the song and all that. But in Amarillo, there's something called Cadillac Ranch. This guy buried 12 Cadillacs, right? And you go out there and spray paint them and take pictures of them. The guy that created that is a guy named Stanley Marsh, long dead. But he was in this case with me some time ago. This guy, Stanley Marsh, would have these young boys come to his office in the Chase Tower in Amarillo, and he would pay them to perform sexual favors, not only with him, but also with each other. And he had been doing this for years, and it was well known in Amarillo. He was very, very well connected, very rich, old family, married to one of the old families of Amarillo. It was just, everybody was like, oh, that's just Stanley. That's just Stanley being Stanley, right? One day I got a call from a lawyer from Amarillo who said, Tony, this is what's going on. And so I said, I'm going to send a plane for you. I want you to get on the plane. I want you to take the mom and get her on the plane and get the young man on the plane and come see me. So when they came, the first thing I would tell you when you're screening these cases, talk directly to the victim. Okay? Make sure that they pass your smell test. And we all lay aside all the movement for this year. We're on Zoom.
Sorry.
We're bleeping that out.
Yeah, bleep that. I've said words. But I did that with this young gentleman who was 16. He told me the story, asking a few questions, but I wasn't heated in that way. I was in the process. But I was blown away. But I told him and I told his mother, I said, we do this. It's like I told the young woman that started this whole Deshaun Watson case. These people are nasty. People are nasty. You need to make sure they know that when you step up, like we used to say in the Marine Corps, once you put your head above the parapet, people shoot at you, right? People shoot at you. And you need to make sure that they're well aware of it. So one of the ways that you can deal with these cases is do it privately. People have criticized me for that. Criticized, in the Deshaun Watson case because we attempted that. But it was the best thing I thought because it's a sad situation, but people blame the victim. If you think in your personal injury cases, people blame your victim, which they clearly do, they times 10 in these sexual assault cases. They look for everything that your client has ever been involved in. And, you know, we had, of course, a very well-funded team, as an example, in the Sean Watson case. In the Stanley Marsh case, we have Sussman Godfrey, my law firm, who's defending them. So, you know, they did a deep dive on each one. It turned out to be, I think, 28 young men that we represented who have been subjected to the same conduct. And I would always tell the clients, don't read the comments. You know, there's a story, don't read the comments, because people sitting in their basement behind their keyboard where they can say some really nasty things. So the first thing I would say, if you can try to resolve it privately by letter, try to do that. Probably the best thing for everybody concerned, because once you step forward and file a lawsuit, it's a public lawsuit, it's somebody who knows, they're kind of left with no other approach than fight you to the death. There's many, I could really put some white and a lot of hair here if I were to tell you the different people across this town that I represent people against privately, who've agreed privately with counsel, who've agreed privately to apologize and pay money. There's nothing you can do. When we're doing in personal injury cases, somebody loses their leg, it's burned, somebody loses their leg. You can't fix that, right? Well, it's even, I would suggest it's even worse in a sexual abuse case, sexual assault case. You just can't fix it. And unfortunately, money doesn't really change a whole lot, to be honest, but that's all we got. Right? So sometimes I have to get like an apology. That assuages them a little bit. Payment of money, maybe a promise to go to counseling. Those are things you got to think about, all the possible things that you can ask for beyond just the payment of money. Be creative and try to resolve it. I hate to say it, but I'm a guy that I don't send them letters to. One of the things in our law firm, we don't talk to adjusters. I got a law firm. I don't talk to adjusters. Adjusters called me and said, "Fuck you, I didn't talk to you. I got a law degree for a reason, right? You know, have a lawyer, call me, and we can talk." But on these cases, I really recommend that you try to resolve them privately. It's the best thing for your client. I hate to say it. Now, some clients want public vindication. In those cases, I think most people will tell you, even in the PI practice, anybody that wants that kind of may be somebody who's never going to be able to happen anyway. So you got to be very careful about that.
One thing that I really found fascinating about the Sean Watson case,
Which we're going to not talk about.
not, but, right, and on topic of contemporaneous evidence, how the criminal procedure, criminal process kind of intersected with civil process, and the role, for example, of the Houston detective in the grand jury investigation at the time that the first deposition took place, a clip of which I'm going to play, you know,
If you can, if you have the time, remember the statute of limitations against the PERP is a lot longer than against the institution. You got to make sure that you understand that. The statute of limitations against the PERP, which is 6 in Texas, I think, 5, 6,
5.
It's a lot longer than 2, right? But the statute of limitations against the institution, I'm looking at cases right now against fraternities, against other institutions. You got to be very careful about that. Make sure as soon as a call comes in, put that on your calendar. Make sure you get that. Don't screw that up. But if you can, if you have the time, you absolutely should have the victim go to the police. You really should. And the reason I say that is not because I think the police didn't do anything. I mean, I think we were blessed in this particular case that we had 2 detectives who were really professional, really receptive. I was just very impressed by them. I think they played a clip from one of them. But most people, the general public and juries, are always going to wonder why you would cause. And you can tell them, well, only 1%. sexual assaults are ever prosecuted, and literally treated like you're the criminal. But they don't buy that, right? So you should make sure if you have the time to make that happen. And most VAs would use your civil case as an excuse not to do their jobs, right? I've had so many cases, whether it be Galveston County, Harris County, lots of counties across the state, where if you file a parallel civil proceeding, the DAs look at that as if you're impeding upon their territory, and then they're just like me. Right? They pretend that that somehow hurts the criminal case. They pretend that, well, this is all about money. So if you can, if you have the time, I would strongly suggest that you, if the victim chooses to, it sucks. If you've ever sat through one of those interviews or had clients of yours that did that, you know that when they do a deep dive on you. Harris County, to their credit, Houston uses a third party now. But back in the old days, for child sex cases, when I used to do a lot of those, they would have a third party come in and talk to the child. And they would video it. It's a forensic interview, they call it, I think. Now they do that for all sexual assault victims. So they have a third party that does that. To their credit, I think they're very good. But if you have that time on the statute, you should do that. You should let your client, or at least encourage your client to make a police report. Typically, we all know it's not supposed to come with evidence, blah blah blah, but you should do that. I would make sure they know not to expect a lot from that process, but at least do the process.
We want to talk about, yes, go ahead.
So you saw Washington case, it seemed like you're naturally going to get a lot of media attention. To be honest, it seemed like a master class in how to handle media to your advantage. Was that naturally reactionary just because of the topic and the players in that, or was it something that you used?
I've had a lot of
strategically?
practice.
That's actually exactly what
I've had a lot of practice. And it goes back to what I told Ashley, somebody's going to be. This is going to play out publicly. The judge brought us in. We had a great judge.
Who was your judge?
Rebecca Collier. Great judge. She was put up with me and Rusty Harden. She has to be a great judge, right? But be very particular and careful, contrary to what people think. I know what the rules are with regard to pretrial publicity. I know the rules, they're burned in my brain, right? So I never step, contrary to what people think, I never step beyond those. I got kicked out of Iowa. Probably don't know that. I got thrown out of Iowa. Can you believe that? Iowa of all places? I never even wanted to go there and I got thrown out of Iowa. Screw Iowa. They threw me out. Anyway, because of pretrial publicity, in some cases we had in Iowa. But I appreciate you saying that. But we knew from the beginning, because of who the defendant was, that there was going to be a publicity element. I don't use people. I used to have somebody on staff. Steve Sussman told me one time on a plane, he said, something to the effect of, you don't beat your own drum, nobody else will beat you, right? And he used to have, in his law firm, his PR person was was the most important person in his firm, which was right across from his office, which he talked to her every single day. I don't have that. I used to have that. I found that I handle it myself. People take it, when I tell them something, they take it more to the bank, if you will. They take it more seriously. And so I managed all that by myself, with the understanding that a lot of this was going to play out publicly. I knew it would, just because of, and I told the lawyer, there was a lot, again, I can't disparage this person. I'm really fighting to disparage this person. Or even mention his name, although I know his name. I know where his office is. I know what street it's on. But lay that aside.
That's where we're having lunch.
Yeah, well, maybe we should go. Okay. But I told that lawyer, remember quite clearly, you may have been on the call. I told him, let me tell you what's gonna happen. I'm gonna file a lawsuit. You're gonna hire Rusty Barton. And then here we go. And that was a year and a half ago. I told him exactly this. So I was prepared for all that. I knew exactly what was gonna happen. I didn't know, there was a few things that happened that I took advantage of, right? But I appreciate you saying that, but they're always, if you're suing somebody who's a public person, there's always that element of it. And I think we do a pretty good job of that. I can tell you the last time before last, I went and hit the jury. I think there was like 3 people out of 100. We had to bring in 100 who did not know me and did not have some kind of opinion of me. Whatever it is. Not maybe it's the mayor run or maybe it's the Sean, I don't know what it is. But we had to spend some time, happening. The good news is most of it was positive. So there was something like yeah, my daughter, who at the time was going to NYU, getting her master's in counseling, shamed me into taking it. I sent a text. We have a group text. I'm sure y'all have that too. We have a group text, and I said, guys, if my family's really involved in what happened, so very happy about. There's some lawyers that family divorce. My family's very engaged. And, I said, here's the situation. What do y'all think about this? My daughter, who knows exactly how to get it. She said, Dad, that's why you went to law school. That's it. That's the reason you went to law school. And I couldn't disagree. That's the reason. So I never expected that those cases would turn into, a lot of money. Certainly think we were fighting a good fight.
Kind of technical one. Mattia Tandrege and I picked the jury.
I know this young man.
Yeah,
I know his sister very well.
well, don't storm out.
Yeah.
He and I picked the jury together a few years ago in a sexual assault case. And the defense lawyer, during voir dire, his first question was, who has some connection to a sexual assault? Who knows a victim of sexual assault? And I would say 90% of our jurors, which opened them up to an easy strike. How do you handle that? How do you rehabilitate those folks? How do you approach voir dire when you live in a world where this happens a lot?
Well, I'm just going to give you some general voir dire tips. Directly to your question. You already know when you spend time talking to these jurors. My view is the funnest thing I do. Being able to talk to people are forced to listen. And first thing I always do is say, who among you wants to serve on the jury? Typically, even out of 100, you may get 5. By the time I'm done, it's literally 75%. And if you do your job, that's how it should be. They should want to do something bigger than themselves. So when you find those people, you know who they are, that are really your jurors, you have to immunize them. You have to. You have to make it clear that you can be empathetic without being biased or prejudiced. Right? Just because the first instruction says do not let bias, simply or prejudice play a part in your decision, does not mean that you can't be empathetic or have sympathy. Right? And so a lot of times I spend a lot for good jurors that I know that they're going to immediately key in on and try to strike. I go to them and I, as a prophylactic measure, protect them, give them what they need to say when we know the question's coming. Right? So that's the best advice I can give you. But you'll know who those people are if you're doing a good job. Because hopefully, if you're doing a good voir dire, they're doing all the talking and you're just doing all that listening. Hopefully. But there's always, like the last trial that we've had, I think I struck for cause like 25 people. and they struck for cause one. Right? And that's because, and there were lots of people that, and remember, the new case law is that you can rehabilitate jurors. That's the new law, right? I agree with it, but that's the law, right? Because of course, I do a brain dump right after every trial, so I try not to carry all that crap around my brain. But that would be my best advice, is make sure that, obviously, you don't want to spend a lot of time talking to those people, because the more they talk, the more likely it is they're going to get struck, right? But you do want to spend the time to make sure you give them the tools they need to prevent themselves from getting struck. There's this thought in Gore Dyer that, oh, I don't want to hear anything bad. I don't want them to poison a jury. That is exactly right. There's no poisoning in the jury. That's just a bunch of bull. Because somebody says something that's outrageous, it's really terrible to your case, or terrible to your theory, or terrible, about you. Most of the time, you'll see people for you rally around you, and it even more ensconces them in their position against that. So you want to hear that, right? But what you don't want to do is think, lawyers, we love to hear people say good shit about us. Right? That's what we want. Oh, they were saying, they loved our case. You're not doing your job if that's what you're spending your time for. Right? So you figure out who those people are, make sure you protect them, tell them exactly what they need to say. I've had some jurors potential jurors that I thought, oh my God, they're never influenced. They are so pro-claim. They're so anti-oil company. But I would just tell them, I look at them and I say, give them a little magic dust. Right? And they make it on my jury.
The answer is magic dust.
Before,
Everybody write that in.
before my daughter used to take tests, she said, "Dad, can I get some?"
One of the questions, some other notable cases that we handled, like for example, one case that was a rape case against a very popular establishment in Houston that we all.
Brennan's.
Well, I was gonna say,
Can I not say
I don't know, down, it's public record.
You said it. Brennan's has really great turtle soup. Great turtle soup. The challenge in these cases, and I think we all are struggling with, is what are these cases for? And that's probably the biggest challenge. What are these cases worth? Because in a personal injury case, we know we can say, here's what this worker could do before, and here's what this worker could do now, and here's the reduced the present value, blah, 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 life expectancy, work life expectancy, all that stuff. That's easy. Right? In these kind of cases, it's so hard to put a dollar value on it. So what I would suggest to do is you just, you go to the verdict search, you try to just show that this is kind of a similar situation. Here's what juries, here's how they look at these things. Because it's so personal. When somebody takes advantage of somebody else like that, it's so personal. It's really, really hard to place a dollar value on it. And a lot of times when you're dealing with a defense lawyer, she or he is having that same struggle, trying to advise her client or his client about that situation. It makes it very difficult. So really, a lot of times it comes down to personality. It comes down to keying in on some really egregious facts and really just doing the best you can. Ultimately, though, I think the smart play, if you can resolve it, try to resolve it. Because who knows? I can tell you 9 times out of 10, I go try to personally get a lawsuit. Pretty good about what my chances of winning are. Pretty good about what my damage model looks like. There hasn't been, I've tried a lot of cases, maybe been 5 where the jury did not give my medical damages to the penny, my economic damages to the penny. Right? This last case we just tried, they gave about $4 million each for pain and suffering and mental anguish for a non-operated back with 2 injections. Right? So I'm usually pretty good about predicting that. These cases are really unpredictable.
Yeah, I had a case. How do you convince the family that it'd be better to file a lawsuit than to raise the damages. I had a representative family whose daughter was molested by a mover. And they lived in Westview, and took them like 6 months to talk to a lawyer that came to me. We settled it, pre-suit, but I knew, and the lawyer knew on the other side that she didn't want to file suit somehow, and so the damage was just not what it's worth at all. And so what advice can you give on,
I've had that same problem.
they don't want to file
They
suit?
don't, no, I've got cases right now where they don't. I handle cases against the Catholic guys, they don't, with Catholics, they don't see the Catholics, right? I have the same struggle. You can only, beat the drums, if you're gonna go do this and do that, but sometimes, especially parents.
Yeah, it was parents with young child, all these communities are this big. And the kids were young, they still go, so
It's a struggle.
it was. I mean, it was like the nephew of the owner of the moving company, and pictures were still on the phone 6 months later. I had some good facts, but they weren't interested. We got it, okay, some, but nothing. I don't think we-
And maybe you did the best, maybe that was the best
Yeah,
result.
but that,
I don't know.
they,
I had a case against an institution here where I negotiated over a year. And I had about, I want to say about 3 or 4 million on the table. And they didn't want to take it. They didn't think it was enough, and they just walked away from it. And they didn't want to file suit against this institution because they didn't want their child forever when you search their kid's name, their name on behalf of their kid would be in the record. And so I wish I could give you that answer on that. Thank you.
So as when we first, before you spoke to our plaintiff, after you were very skeptical of the story,
I'm never skeptical of her story.
Okay.
Skeptical of the
Okay,
case.
got it.
Never of her story.
Well, my point in saying that is it important that you evaluate the credibility of the client. She weren't as strong as the client. She didn't have, she had a terrible reputation. If she was not someone that you would have then I think that would have changed your approach to litigating.
I think you all, and I think that goes back to what we said, you all have to know that you think this is somebody who can carry this. She was somebody I felt like I could carry this. She was solid person. So your point is well taken. I personally spoke to her, personally listened to what she said, just like the young man from Amarillo. I listened to what when they came in, told the mother, leave, told the lawyer, leave. Let me talk to the young man myself. And I heard his story, and I was like, okay, that's a story that I can get behind. That's a story that I can put forward. If you, in these kind of cases in particular, because they're so nasty, because they're so personal, if there is something when you're talking to the person that you don't feel like you can get behind, you probably should move on. You should make sure that you're absolutely engaged and involved, or yes, like fully support this person. And actually, so it's certainly somebody. We got another thing about that I want to mention, because I think somebody said it. Contemporaneous evidence, so important. Right? Most jurors are going to say, well, if something like that really terrible happened to you, there's probably one person in your life who you share things with. Did you text your mom? Did you text your best friend? You want to collect that. You want to see if that exists, right? There's been much ado made in this Watson case about the text. And one of the things that we're really good at is we collect all that information immediately. We take our client's phone. We don't rely on the client to tell us, here's all my text was X, Y, Z. We take their phone. Let's see, the man that does that. Devlin's good. I've used Devlin before. He's somebody that we use. Devlin could take their phone, get everything on it. So I recommend you write his name down.
Well, I think we, thank you. Does anybody have any questions? I think we should wrap up, but I do want to play that demo clip, Dennis. It was like the second to the last slide. This version of the PowerPoint.
Who was taking the demo? Oh, me. I can't wait to watch it.
Dennis, can you keep that up?
It's a short.
So did you pick email plaintiff, email mediator? Is that the way you do that? You think
Probably. I think it was, yeah, I think so. Although I do like Peter Pan. I was all prepared. Yeah. the Easter.
So I don't like it. But it's not judge boss, I'm gonna talk about it, but what I did want to say is that you know, it's a civil case. This is right. Whatever the devil wants to play, they're gonna see one question, one question. That's what I typically do. Question. You know what? That's my constants as well. They're doing what you want to do. Essentials. So the point to all the videos, but it's had that. It's kind of use all that. Right? Sure. Let's go. So it's a different mission once. Okay. Born September 14, 1995. You know, started
So that shortly thereafter, the grand jury no bills in and, you know, rest is history, but this is a prime example. The
The
game's-
best thing that can happen to you in your cases is there's a parallel proceeding and your perp takes the bill. We all know how that works in state court, Texas. Every court across the country is the same. Make sure you know the law involved. California is a little different. Wherever you're litigating. But getting that deposition, getting that defendant under oath, getting that defendant to take the fifth, that's powerful stuff.
Well, does anybody have any questions? Otherwise, thank you to my mentor and colleague. Spotlight.
Yeah, I'm sorry.
Thank
Thank you, Chris, very much.
you, thank you guys.
I thought we were gonna hear from the detective.
Oh, no, I didn't.
Oh, you didn't.
We've gone a little bit over time, but you guys are invited to stay for lunch if you've got to run. I'm not to understand that. But hopefully we'll see you guys all in a month. Thanks so much, Tony. We are done.